Good morning. I would like to read the judgment first, then I will proceed and discuss what are the provisions dealing with this subject. They say uh, the trial court to recall NBW issued against the petitioner, not insisting the presence of the petitioner. In the case tried as summon procedure, the petitioner is facing trial for offence under section 499 IPC. It's a definition class, punishment is 500 IPC. Wherein the maximum sentence only 2 years as per section 255. The presence of the accused is not 255, that must be 253. Necessary for rendering judgment in the court. In someone's case can render judgment in the absence of the accused and according to the nature of the judgment, appropriate or thereafter be passed and the presence of accused not to be insisted. Therefore, V. Rajnarayan versus S. Ramamurthy, 2021. V. Rajnarayan, S. Ramamurthy, 2021. 2 Law Weekly Criminal, 885 Madras. That is judgment. Before that, I would like to discuss with you what all are the provisions when you file an application seeking bail under section 436 bailable offences. If the FIR is filed for bailable offences, you simply file bail application and file surrender petition. So that provision for filing surrender petition is under section 44 CRPC. 44 CRPC says? 44 CRPC says when any person when any offence is committed in the presence of the magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender and may thereupon, subject to provisions herein contained as to bail, commit the offenders to custody. That is one provision when the offence is committed in the presence of him. Another, second, 44 class 2. Any magistrate, whether executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent to at the time and the circumstances to issue warrant. So, if the FIR is pending before the particular magistrate, you can ask the magistrate by surrendering yourself. Then you can seek bail. Then question of 70 class 2. A warrant of arrest shall ordinarily be directed to one or more police officer, but the court issuing such warrant may its immediate execution is necessary and no police officer is immediately available, directed to any other person or person and such person or person shall execute the same. That is for issuance of warrant. So 72 says warrant may be issued even to the accused, even to the complainant or any third person. Then the question says, when a warrant is directed to more officer or person, then it may be executed by all or any one of them. What is 70 class 2? Every warrant of arrest issued by court under this code shall be in writing, signed by the presiding officer such court and shall bear the seal of the court. That is nature. Then subsequently says, every such warrant shall remain in force until it is cancelled by the court which is issued it or until it is executed. So there 70 clause 2, when you file recall of NBW, it is not necessary that accused should present, but an affidavit or undertaking that he will appear regularly as directed by the honorable court is sufficient. Then why this judgment deals with 253? 253. What 253 says? It is trial of summon cases by magistrate. Where a summon case has been issued under section 206 and the accused decide to plead guilty to the charge without appearing before the magistrate, he shall transmit to the magistrate by post or messenger a letter containing his plea and also amount of fine specified in the summons. If suppose summons is issued mentioning about the fine amount, then he can very well give a letter of letters directing to the a magistrate to accept his plea of guilty and amount may be paid. Then they say the magistrate in his discretion convict the accused in the absence on his plea guilty and sentence to pay the fine specified in the sum, and the amount transmitted shall be adjusted towards the fine. Or the pleader authorized by the accused pleads guilty on behalf of the accused. The accused shall record the plea as nearly as possible in the words used by the pleader, and may in his convict the accused on such plea and sentence him as aforesaid. This is what 253 says. Therefore, the judgment which I referred shows that you can very well file a warrant recall petition without insisting. Similarly, there I said 44 petition under section 44 class 2 wherein you file civil surrender petitions, then you can very well file for seeking anticipatory bail. Suppose anticipatory bail is granted, the order may say that in the event of your arrest by the police officer, or if you surrender before the court stating that the offence has been committed within the jurisdiction of this honorable court. Therefore, that way of drafting, you have to slowly start from the trial court. It's not that you get a printed form and fill up it and file it. Sometimes that due to lack of time and late approach of the accused and due to other transport disturbances, you may get the forms. But it is far better that you try to draft petition before the lower court itself whenever you have got sufficient time, corresponding to the provision under which you have applied. Don't simply file surrender petition. File surrender petition under section 44 class 2. Don't file 70 class 2 simply that with accused is not. You file an affidavit stating that for what reason accused is not appearing and for what reason the court is not supposed to insist the appearance of the accused. That is the way you have to develop your drafting. See, when I have started my practice in the year 1981, my senior Mr. M. Kamalnathan used to dictate me because I worked as a stenotypist in department, Post and Telegraph department, even for 317 CRPs. That is the way of his dealing with the cases. But therefore, you better try to draft your petitions slowly, in conformity. Always, all the petitions should be in conformity to the provisions. So you cannot file 317 simply that appearance of the accused may be dispensed with. It is not that. You must say that and allow his counsel to defend his case. That is, if you are not in a position to defend your case, then you have to file 309 petition stating the reason as to why you are not defending the case. So all these corresponding provisions are related to incidental proceedings. Miscellaneous incidental proceedings, but that bears a lot of slow knowledge so that you can develop your argument before the Honorable High Court. What 482 CRP says, you simply go there and file 482 CRPC if you could not succeed before the lower court for recalling the warrant, whatever it may be, the petitions you are filing to recall the witnesses. Because inheritance means son inheriting the property of the father and father inheriting the son's property. Like that, the High Court inherits the power of the lower court and passes orders as if lower court, if the lower court failed to do so, and to meet the ends of justice. That is the reason. Therefore, you have to state some reasons in the lower court, though there was a provision to recall, though there was a provision under 311 CRPC to recall the witness, whatever may be the grounds. You have specifically stated the lower court failed to exercise the power under section so and so, either 70 class 2 or under 311 CRPC. Therefore, this honorable court may exercise inherent power and Maybe please to set aside the order, recall. This is the way you have to file the petition. Best wishes.